we're getting closer and closer to the end of the Lynn Haven corruption case. And yesterday, the final pleadings were submitted by the defendants, former Lynn Haven Mayor Margo Anderson and former current developer James Finch. Here's where we are in the case. There was massive corruption in Lynn Haven before and after Hurricane Michael. Several people were arrested and several people pled guilty. 2 did not, Finch and Anderson. And they're going to end up going to trial unless the Chief Judge Mark Walker, dismisses the case with prejudice, because the defendants claim in their motion to dismiss that there was prosecutorial misconduct, violations of the Sixth Amendment, attorney-client privilege with an informant, a confidential informant. And so the defense filed a motion to dismiss, and in March, there was an evidentiary hearing, a 3-day evidentiary hearing that I attended, 2 of those days, where evidence was presented and witnesses provided testimony to the judge under oath. It was unbelievable. Unbelievable. And so these are the pleadings about that. So the judge will make a determination at some point now. Could be a few days, could be a few weeks. Sometime he's going to decide whether or not to grant the motion to dismiss with prejudice or to deny it. If he denies it, they go to trial. And that'll be incredible. If he grants the dismissal with prejudice, it's over unless the prosecution decides to file an appeal to a higher court. If the judge grants a motion to dismiss without prejudice, that means that the prosecutors can go back in front of another grand jury and get a 4th indictment, a 4th one. So this is hot and heavy. I could not read to you the government's documents because they submitted them to the judge under seal, all right, secret. I cannot read to you Margo Anderson's because that's not available either. The one I'm going to read you tonight is a public record. It's been filed with the court, and that's how I am able to do that. So, since it's the only one we have, let's do it. And it's something. I gave it a once over. Now I'm going to read it word for word with you. You got a minute? You want to see what Defendant James Finch and Defendant James Finch is saying, why this case should be dismissed. And if you remember, I was at the evidentiary hearing, and I've read only the pleadings that I've shared with you because they're the only ones that are public. And from what I've seen, I am betting that Judge Walker will dismiss it because of Sixth Amendment violations and false statements made to grand juries enough times and reckless enough in order to get an indictment. That's what I see. Now, it could be that the prosecution has all kinds of good stuff, true stuff. They just haven't shown it yet. When Judge Walker asked them at the evidentiary hearing, do you want to show your side? They said, no. We'll just submit it in writing. And again, that was under seal, so I don't know about it. But I do know what you're about to see right after this. Don't let back pain and neck pain get you down. Find relief at Brown Chiropractic Center on St. Andrews Boulevard in Panama City. Dr. Sherry Brown helps people heal naturally with chiropractic adjustments and deep tissue massage. Call 769-3777.
Hand caught in the cookie jar? Sometimes bad habits continue even into adulthood. I'm El Saulene, 850-215 0628. Let me help you.
All right, let's get right to it. Here it is. This is the just filed pleading. It is the final rebuttal. And now Judge Walker will make his ruling on whether or not to dismiss the indictments against James Finch and Margot Anderson at some point. All right, I'm going to read it to you. So it is the redacted reply in support of his motions to dismiss the second superseding indictment. And it gives a reason why they're able to do that. Here, and it was filed there in the blue. Here we go. Regrettably, the government has yet again, remember, this is James Finch's point of view. Okay. So I'm not saying everything in here is true. I am saying that what I'm seeing in here is supported by what I saw in the trial in March. But this is, remember, the defendant's case. Regrettably, the government has yet again filed a lengthy, fact-twisted, legally challenged 216-page post-evidentiary hearing response to our pending motions to dismiss. The legal issues raised in our motions to dismiss are serious ones. They involve specific, important constitutional violations that deserve careful, thoughtful analysis and attention and analysis. Finding that redacted and being redacted, the court patiently and attentively granted the parties nearly 3 full days of its valuable time, taking testimony and reviewing evidence. The government papers do little to meaningfully address the serious core constitutional issues raised in the motions and 3 days of testimony and evidence. Here are a couple of footnotes. Following the defendant's original motions to dismiss the second superseding indictment and prior to the court's evidentiary hearing, the government filed an 80-page response. That response made abundantly clear, as we suggested in our reply, that the government has lost their way in this case. As demonstrated herein, their 216-page post-hearing response disturbingly supports this contention. Footnote 3, the defense called multiple witnesses. Now, this is what I saw, and this was remarkable at the evidentiary hearing in March. The defense called multiple witnesses. Almost all of them are listed as government trial witnesses. The defense further introduced hundreds of pages of documents generated for the most part by the government, albeit in violation of the court orders requiring timely production. In response, the government called a single witness, the ex-case agent who retired shortly after the defense raised serious constitutional violations and whose testimony the government had originally sought to exclude. Indeed, stripped of its extraordinary length, we're back to the narrative now, and condensed to its essence, the government admits to repeatedly violating this court's orders, knowingly allowing false and misleading testimony and exhibits to be presented to the grand juries, and conceding that unsupported, unproven allegations against Finch were presented to multiple grand juries. Finally, the response glosses over the serious Sixth Amendment violations, including the government's attempts to invade the defense camp using an operative it now repeatedly refers to as a blank. Redacted. In sum, the government would have this court believe that its misconduct did not occur, or if it did occur, it was either redacted or the result of a redaction. Footnote 4. In response to defendants' motions to dismiss in the second superseding indictment, the government fought to protect its confidential source that was providing it with defense information about Finch and others then represented by counsel. Okay, so when you are a target or a witness, and you have an attorney, that changes the way the FBI can communicate with you. They're supposed to talk with your attorney. It's illegal for them to send confidential informants to talk to you, to try to get information about maybe your defense strategy or upcoming defense strategy. That's what this is about. In fact, in the government's own words, it suppressed the source documents because it redacted Greg Wilson. On March 18, 2022, the government untimely produced some of Agent Borghini's handwritten notes, he's the FBI agent, of his conversations with Wilson. Despite the obvious relevance of these notes, the government indicated that it would prohibit Borghini, the FBI agent, from testifying pursuant to Finch's subpoena about anything related to Wilson. While the court was in recess over the weekend, Finch served a subpoena on Wilson for his appearance on Monday, April 4, 2022. I was there during his testimony, where Wilson testified in detail about his agreements with FBI agent, I'm going to say FBI agent so we keep that straight, receiving immunity from the government, and the government's use of him as an informant. After testifying, the government was quick to redaction, recharacterizing its relationship with Wilson, calling the FBI agent as a witness, and describing Wilson as a redacted. After the hearing, post-hearing, we supplemented the record with cell phone screenshots of text messages between Wilson and the FBI agent demonstrating that the FBI agent testified falsely and Wilson truthfully. Switching from a redaction worthy of government secrecy and protection to a redaction, the government's disingenuous tactical allegiance is woefully transparent. Confirming that the FBI agent provided false evidence to the grand jury, but calling it a redaction and a redaction error. Respectfully, the court should reject the government's hollow arguments of denial, deflection, inadvertence, and mistake. The prosecution has attempted 3 times now to strike hard blows. In each attempt, the sovereign has fallen woefully short. Footnote 5. While a prosecutor may strike hard blows, he is not at liberty to strike foul ones. The government in this case has repeatedly struck foul blows. As a result, the court has dismissed the case multiple times over the course of the past 16 months. As a result of these failed attempts to repeatedly twist the law and the facts to support a viable prosecution, James, his family, and his businesses have suffered greatly. Lives have been changed forever. James has worked tirelessly his entire life to establish an honest and honorable reputation in the community for tenacity, truthfulness, and philanthropy. Bribery and corruption are simply not in his character, as many upstanding individuals would testify. Finch's family has lived under the dark cloud of false accusations that have regularly appeared in the newspapers due to repeated prosecution press conferences, describing the intensity of the media's coordination with the United States Attorney's Office for the Northern District of Florida. Even worse, Finch has fought this legal battle while continuing to fight a progressive and dangerous cancer. In short, Finch, his family, his businesses, his employees, and his employees' families have suffered profoundly from the government's false accusations. Chris Forehand, big redaction. With great deference to the court, we respectfully suggest that the time has come to bring this matter to a close once and for all. Footnote 6. On January 29, 2021, the court dismissed the first indictment, requiring amendments to factual allegations and corrections to multiplicitous accounts. The court then dismissed several counts as insufficiently pled. On August 19, 2021, after careful consideration, the court dismissed, that's supposed to say count 1, not court 1, count 1 of the superseding indictment. Incredibly, despite the court's order, the government repled count 1 of the second superseding indictment in virtually the same exact fashion, the exact same fashion. All right, back to the narrative. Page 5 of 35. Bringing to bear the awesome power of the United States government on its citizens should reflect sober, restrained prosecutorial caution and care. The Constitution and this court's authority should be strictly adhered to. Court orders and the rules of engagement should be followed to the letter. Here, the record is filed with a series of extraordinary violations by the government, evidencing disregard seldom seen or reported in case law. And in attempting to understand the government's conduct, including the constitutional failures apparent from the current record, the prosecution's reported, documented history of abuse must be examined. As a result, based on all the circumstances, the court should dismiss yet again the charging document in this case, and fully recognizing that it will never be the normal practice or the usual case, The court should dismiss the second superseding indictment with prejudice. Footnote 7. The United States Supreme Court has repeatedly exercised cautious restraint in construing the so-called honest services statutes at issue in this case. For example, citing case law, the Supreme Court declined to permit the federal government to enforce bribery statutes in a manner, quote, setting standards of good government for local and state officials, end quote. Again, rejecting the federal government's request to effectively use honest service statutes as an all-encompassing method to create a federal standard of good government for states. Footnote 8. Describing the unusual nature of the proceeding, because the circumstances justifying the production of grand jury transcripts had not happened in the court's experience on the federal bench. Quote, when a defense lawyer, this is what Judge Walker said earlier in this case. This is Judge Walker's words now. Quote, when a group of defense lawyers come to me and says, Judge, I found the dog's tooth in my chili. There's probably a good chance that I'm going to let the defense lawyer go back and look in the kitchen. Number 2, the government concedes it has disregarded court orders and constitutional responsibility regarding discovery. The government concedes that it has repeatedly and flagrantly violated its court's orders and its local rules. Since the inception of this prosecution, the government has violated the court's instructions to, quote, disclose to the defendant all exculpatory evidence, that is, evidence that favors the defendant or casts doubt on the United States' case as required by Brady v. Maryland. Exculpatory evidence that the prosecution is required by law to give to the defendant is known as Brady material. Okay, so when I say Brady material or Brady, they're talking about that. And its progeny and order to the United States to do so. To remove any doubt, the court clarified that the government has a duty to disclose any evidence that goes to negating the defendant's guilt, the credibility of a witness, or that would reduce a potential sentence. Footnote 9. Quote, those who fail to learn from history are condemned to repeat it, end quote, Winston Churchill. Admonishing and ultimately sanctioning the prosecutor after dismissal of the indictment for recklessly pursuing prosecution based on fabricated statements and speculative grounds, admonishing, quote, the prosecutor's use of the indictment process, end quote, as grossly irresponsible. The conduct described in the Eisenberg order and the Clayton opinion is worth carefully comparing issue by issue to fully understand the misconduct in the case sub judice. I'm going with that. Now, what this is about, the senior prosecutor and the assistant U.S. attorney in this case was admonished in previous cases years ago. Pretty shocking ones, actually. So the defense is bringing up his history. That is not very good on those two. The government was also fully aware, not very good is, by the way, quite an understatement. The government was also fully aware of the consequences of violating this order. Quote, failure to disclose exculpatory evidence in a timely manner may result in consequences, including, but not limited to, exclusion of evidence, adverse jury instructions, dismissal of charges, contempt proceedings, disciplinary action, or sanctions by the court. The government now concedes it has repeatedly violated the court's discovery order and defendant's constitutional rights, but suggests that dismissal with prejudice is inappropriate. Redaction. Recanting its prior written statements regarding additional Brady material, conceding that redaction with earlier productions redaction. Incredibly, the government now suggests that its multiple and repeated violations of court orders, the deliberate withholding of discovery material, was somehow justified. In fact, the government claims that the intentional delay in withholding was redaction, despite having no legal justification to withhold discovery, making conscious decisions to violate this court's order. Finding in favor of the government on this issue effectively condones prosecutorial gamesmanship, encouraging future prosecutors to discard decades of binding case law and clear court orders requiring the timely production of discovery material. Footnote 10. The government also conceded that it violated the court's instructions to provide Mayor Anderson, with a potential witness list following her arraignment. Of course, it has likewise never provided a witness list to Finch after his initial appearance, choosing instead to provide a 2-page no-contact list containing, quote, the names of the individuals that Defendant Finch should not contact. A. The government concedes it violated the court's orders with respect to Chris Forehand's reports. He is the engineer still. He is the engineer in Lynn Haven that gets contracts to do engineering work for Lynn Haven. That's who Chris Forehand is. As argued in our original motions to dismiss, we were perplexed with the government's disclosures regarding Chris Forehand's multiple interviews. These are interviews with the FBI or investigators. In short, other government witnesses place Forehand at the center of virtually every aspect of this case. Yet the 302 reports, those are FBI notes, official FBI notes, of his interviews report no criminal admissions or denials. As now revealed, it was simply a sleight of hand argument. The government asserted that, redaction, this ignores the significant fact that all of Forehand's interviews were devoid of any mention or reference to WorldClaim, not just the first several. That's the insurance company that did the adjustments. That was the adjuster. And as the defense continued to repeatedly request the disclosure of all agreements between the government and witnesses, the government either refused to disclose this information or avoided answering our requests. Remarkably, we now know that the government had an unrecorded verbal agreement with Forehand, permitting him to avoid revealing information about his criminal conduct. This extraordinary verbal agreement was intentionally omitted by the government in witness reports. The verbal agreement to avoid questioning Forehand, an unindicted co-conspirator turned government witness, about his criminal conduct was undoubtedly subject to disclosure. But for the defendant's dogged review of evidence, discovering inexplicable circumstances within the government's reports and issuing a subpoena for Forehand's testimony at the evidentiary hearing, this verbal agreement would have never been disclosed. Let's go back to these footnotes. All right. Footnote 11, as previously discussed, the defense continued to ponder the court's initial question of reference. What makes up this wagon wheel? So Judge Walker wanted to know, okay, you are charging James Finch, the developer, and former Mayor Margo Anderson, you're charging them with a grand conspiracy. But where is it? A conspiracy requires other people and a plan and all of this kind of stuff, right? So the judge asked this question: what makes up this wagon wheel? Who is the hub? Who are the spokes? Who is the rim? Now, the defense says all evidence to Forehand points to Forehand, according to the government's own documents. Forehand influenced the hiring of Michael White, the former city manager who was arrested and pled guilty. Forehand bribed Michael White with cash payments. Forehand pressured Michael White and other city employees to hire Tetra Tech for his own financial benefits, ultimately receiving in excess of $3 million. Forehand attempted to cover up his connections to Tetra Tech. Forehand and Michael White excluded critical city employees from hurricane cleanup and FEMA meetings. Forehand and Michael White arranged for the city contract with WorldClaim, the adjuster. Forehand sought kickbacks from WorldClaim for pro bono services provided to, Michael White and another unindicted city commissioner. All right, back to the narrative. I believe we are here. Okay, so let's get these other footnotes. Footnote 12, the prosecutor's attempt to deflect blame and avoid consequences by asserting that the agreement was between Forehand's counsel and the FBI. Redaction. The prosecutors, however, were clearly aware of the strange agreement permitting Forehand to avoid answering questions about his criminal conduct. Indeed, the record reflects that the prosecutors were present during Forehand's interviews when this extraordinary agreement was reached. What they're saying here is that when the FBI and investigators interviewed Chris Forehand about either as a witness or a target or whatever he was, the prosecutors were also there, which is unusual. And that's when he evidently reached a immunity deal. All right. 13. Considering the government's concession that the FBI agent falsely testified before the Tallahassee grand jury on April 6, 2022, and the government's concession that significant information was omitted from multiple FBI formal notes, the court should have grave concerns and serious doubts about all reports prepared by FBI agent Borghini, as well as his testimony as the elusive witness, exclusive witness. Okay, he was the exclusive witness in all three grand jury presentations. He was also elusive, by the way. Twice he didn't come up when he was expected to. B, the government's suppression of evidence relating to Samantha Lynn violated the discovery order. The government failed to timely produce Samantha Lynn's witness report detailing her conversations with Mickey White. He's the owner of ECS, arrested, pled guilty, Mickey White, about manufacturing and backdating invoices days before ECS was raided by Bay County Sheriff's Officer Major Stanford and the FBI. Like many other reports as detailed in our original motions to dismiss, the Samantha Lynn report was not provided until well after the court's February 22nd, 2022 order. The deadline. The prosecutors continue to finally turn over evidence that might be exculpatory way after deadlines. Courts don't take kindly to that, certainly not Chief Judge Mark Walker. Having been caught red-handed, the government now concedes that such information regarding the creation of backdated invoices is redaction relevant. Again, the government attempts to gloss over this violation of the court's order and its constitutional responsibility by arguing that it believed the information from Samantha Lynn was inculpatory. It wouldn't have helped the defense, they said. But the government intentionally ignores the fact that portions of Lynn's testimony are materially different than Mickey White's. For example, Mickey White, remember the owner of ECS, who pled guilty, his November 25th, 2019 formal FBI notes indicates that he prepared the invoices. This is a very important part of this case. These invoices are what implicate former Mayor Margo Anderson. Okay, so these invoices, were they fake? Were they real but backdated? There's a major problem with these invoices. And my understanding is we would have to believe that former Mayor Margo Anderson, when she submitted the invoices that drew her attention to Mickey White in the first place, she found a bunch of invoices showing that Mickey White had overcharged Lynnhaven by like $5 million. So she submitted a giant stack of invoices. She gave them over to the sheriff's office. It was in that stack of invoices that the government claims, implicated herself. She turned over her own invoice, an invoice that implicated her as committing crimes. So understand this is a very important point here. It's a really weird thing to think that she turned over invoices that got her arrested. So that's what this whole thing about these prepared invoices are. So Mickey White, the owner of ECS, also reported that they had to look up addresses. Lynn's reports indicate that she prepared the invoices, not Mickey. Lynn further reported that Mickey just provided information off the top of his head. Thus, the reports clearly contain impeachment information that the government was obligated to provide, not withhold. Let's go back to some footnotes here. 13, considering the government's concession that FBI agent falsely testified before the Tallahassee grand jury and the government's concession that the information, okay, we read that one, 14, footnote 14. 2 days prior to the evidentiary hearing, the government notified the defense. Okay. The prosecutors notified the defense that Chris Forehand, the engineer's attorney, indicated that his client would not answer questions at the evidentiary hearing and instead would invoke his Fifth Amendment right to remain silent. Forehand's attorney indicated to the government that there may be some inconsistencies between Forehand's testimony and Michael White's testimony, the former city manager, about WorldClaim, the adjuster. Forehand's attorney further indicated that his client's testimony would not be helpful to the government. The government also notified defendants that at this late stage, it was in the process of granting Forehand immunity. The grant of immunity conveniently happened 2 days before the evidentiary hearing, but was produced after the hearing concluded, again depriving the defense of the use of critical evidence during the hearing. All right, so now we're down here to C. The government's suppression of the evidence relating to Major Jimmy Stanford's violated, the government's suppression of the evidence relating to Major Jimmy Stanford violated the discovery order. All right, now we're talking about the sheriff's office, Major Stanford. The government argues that withholding and redacting the information about Bay County Sheriff's Office, Major Jimmy Stanford, was justified and did not violate the court's discovery orders. Again, after having attempted to cover up the Stanford criminal connection and then being required by the court to unredact and disclose the Brady information, possible exculpatory information, the government incredibly suggests that suppressing this evidence was appropriate since it was redaction. Having been caught and required to answer, the government now admits that a redaction of action would have been to seek relief from the court. Of course, seeking court intervention pursuant to the rules was never employed in this case, even once. Amazingly, the government admits that its discovery misconduct was motivated in part by its desire to redaction. And the government takes it a step further, attempting to justify its improper suppression of Stanford's reports and redaction of information by suggesting that the material would otherwise be inadmissible. According to the government, there was no harm in suppressing it. All right, let's take a look at these footnotes. Footnote 15. In 2019, the former United States Attorney's Office created a public trust unit to restore integrity, responsibility, and trust to public offices across the 23 counties of the Northern District of Florida. That was when Larry Keefe was there. That's what he said his goal was. Did Larry Keefe come even close to accomplishing that? Remarkably, the prosecutors within the public trust unit were fully aware that Jimmy Stanford, Major Stanford, a public official, accepted expensive gifts and other things of value from various documented criminal targets within the government's investigation. Yet the government never sought to remove Stanford from this investigation, aggressively prosecuting others for alleged identical conduct. The hypocrisy is palpable. 16. This is footnote 16. Based on the circumstances, such an argument can hardly be made in good faith. Major Stanford was involved in this investigation from its inception. It involved some of his closest friends. How could his bias, motive, and failure to recuse himself from investigating longtime friends who had provided him with significant gifts as a police investigator be irrelevant and inadmissible? He was disqualified from the case's inception, and the FBI and government knew of this serious and immediate conflict, yet plowed forward. What could be more relevant than the co-case agent participating in virtually the exact same conduct that the government now claims is criminal? Clearly, such information is relevant and admissible. Thus, the government's reliance on case precedent is wholly misplaced. Affirming the trial court's decision to exclude testimony that was unrelated to a police officer's character for truthfulness. In fact, case law supports the admission of Stanford's relationship with Derwin White and Stanford's potential for investigative bias. Examination of a government witness is important, and a presumption favors free cross-examination on possible bias, motive, ability to perceive and remember, and general character for truthfulness, end quote. Moreover, Major Stanford has admitted to many of the improprieties, further distinguishing this case from case law, affirming the trial court's decision to prevent the defendant from questioning a DEA agent about unproven allegations of misconduct. All right, back to the narrative. D, the government's suppression of evidence relating to D.D. Rowan violated the discovery order. The government does not deny that the D.D. Rowan notes, she's a local attorney, were subject to disclosure under Brady, the exculpatory evidence, and its failure to disclose them violated the discovery order, the court's February 22, 2022, and the local rules. The government also fails to mention that it provided FBI agent typewritten notes of his August 25th, 2020 interview with Rowan on April 13th, 2022. Wow, almost 2 years later. So what the official notes are, the 302s, let's say an FBI agent comes and talks to you and scribbles down notes, or doesn't. Whenever he gets back to his office, sometime shortly after, he's supposed to formalize those notes, type them up, and file them. The FBI agent did not do that. He didn't formalize and file notes for almost 2 years. Then the government waited until May 17, 2022, again well after the March evidentiary hearing, to provide counsel with Borghini's handwritten notes of his interview with Rowan with no explanation. So after the evidentiary hearing was over, the prosecutors turned over the FBI agent's notes. The FBI agent's notes reveal that Rowan was closely tracking her referrals to WorldClaim, the adjuster, but Rowan's communications with WorldClaim made no mention or reference to Defendant Anderson, Mayor Anderson. The absence of any reference to Anderson undercuts the government's theories. Even if the FBI agent failed to prepare and submit a formal note, his notes of Rowan's interview fall within Brady and its progeny, and the timing of the government's production proves the government violated both the discovery order and the February 22nd, 2022 order. Allowing the government to disregard its discovery obligations and its court orders of production encourages the government to suppress critical relevant evidence. This court's orders become meaningless. The government's irrational logic is further evidence that serial violations have occurred in this case. The evidence presented at the 3-day hearing firmly supports this conclusion. As a result, dismissal with prejudice is warranted. Let's take a look at this. Okay, we already read through that footnote. So continuing on. Number 3, the government concedes it violated the February 22, 2022 court order requiring comprehensive production by March 1st, 2022. So if you're a defendant and the court says, hey, prosecution, you need to turn over everything you have so that the defendant can defend herself by this date, you better turn it over by that date. Well, the prosecution didn't, not by a long shot. The government attempts to justify its repeated violations of that order of requiring comprehensive production by March 1st of this year through unsupported reinterpretation and self-imposed amendments to the court's order, describing the order as redaction. The court's order, the deadline order, I'm going to call it the deadline order, however, does not include a single mention or citation to the Jenks Act. The deliberate misinterpretation or willful indifference towards the court's order was first evident in the government's March 1st status report. So when the deadline came up, the government indicated that the material the government was producing represents the bulk of the government's anticipated production. The deadline order does not require early or anticipated Jenks material. The court's order specifically requires the production of all witness reports and the notes of agents conducting the interviews. There is no limitation, express or implied. The government's intentional disregard for the court's clear instructions became even more apparent immediately before and during the evidentiary hearing, detailing the government's late and missing productions. Frankly, dismissal with prejudice can be sustained on this ground alone, but regrettably for the government and the defendant's constitutional rights, there is more. In its supplemental briefing, the government extends this sleight of hand misinterpretation to justify the untimely production of confidential human source, an informant, a confidential informant, CHS, confidential human source, reports that were 28 days late. It's hard, by the way, isn't it, to have a speedy trial when you're getting potentially exculpatory evidence 28 days past a court-ordered deadline. I'm going to take a pickle break. Wow. Think about that. Could you imagine being a defendant and having that happen to you? All right. Again, the deadline order does not include any such independent limitation, requiring the production of all witness reports and the notes of agents conducting the interviews. The government is merely creating this limitation out of whole cloth. As demonstrated in defendant's post-evidentiary hearing brief, the government did not comply with this order, violating it repeatedly. Again, dismissal with prejudice on this ground alone is appropriate. Unfortunately, there continues to be more. The government has produced extensive court-ordered material after the hearing. After the hearing I went to, after the evidentiary hearing for the motion to dismiss, the prosecutors still hadn't given over all of the evidence for the defendants to defend themselves. That is unbelievable. In response to the government's late production of rough notes on April 8, 2022, counsel for Finch inquired on April 11, 2022, why the material was not produced prior to the commencement of the hearing as ordered by the court. On April 12th, the government claimed that it had made a diligent effort to provide all witness reports. They did their best, blaming its defiance of the court order on the fact that the material was not in the FBI case file. Again, the court's February deadline order does not limit the scope of witness reports and agents' notes to only those within the FBI case file. Frankly, the court could not have been clearer, and once more, dismissal with prejudice would be appropriate on this ground alone. Footnote 17, on April 12, 2022, the government also conceded to defense counsel that it did not ask for the Bay County Sheriff's Office to produce rough notes until April 1st, 2022. On April 13 of this year, counsel for Finch requested clarification and further explanation as to how and why the government was taking inconsistent positions. Specifically, we asked how the government could claim its efforts were diligent, considering, 1, the government represented to Finch's counsel in writing on March 31st of last year, and Anderson's counsel in September 2020, that it had instructed all agents and officers to preserve all rough notes. 2, on February 22 of this year, the court ordered all witness reports and the notes of agents conducting the interviews by March 1st. 3, the government's concession that it waited until April 1st to contact the sheriff's office and request all rough notes. The government did not respond and still has not responded. Now back to the narrative. The government's willful, repeated disregard for the court's orders is precisely the cavalier attitude that is unlawful and unacceptable. The government is not at liberty to violate the court's orders, including rules of production. The rules are clear. Constitutionally, statutorily, by court order, and by local rule, the government is required to disclose favorable, exculpatory, impeachment evidence or suffer the consequences of its actions. Quote, if a party fails to comply with an applicable rule or a court order, the court may take other appropriate action or issue an order to show cause why these actions should not be taken, end quote. Permitting this repeated flagrant behavior signals to the sovereign in this district and elsewhere that a prosecutor's intentional, Vexatious actions are acceptable so long as there is a belief that they can attempt to cure it at trial and or defend the violation on appeal, employing a harmless error standard. The government's intent to suppress Brady material, at least until trial, is evident by its conduct and by its written response to defendant's motion to dismiss. The 11th Circuit has noted that a late disclosure Brady error will be reviewed by the 11th Circuit under the constitutional standard, not the local rules of the district, end quote. Of course, the record supports the more probable conclusion that the government had no intention whatsoever to ever turn over the Brady information received due to the court on February 22nd of this year. Either way, the government's intentional, flagrant, cavalier attitude toward its constitutional obligations and the court's order should not be tolerated. Recognizing that it would eviscerate the purpose of the Brady rule and encourage gamesmanship, where we had to allow the government to postpone disclosures to the last minute during trial. Improper gamesmanship is unacceptable. Number 4, the prejudice caused by the government's flagrant violations of court orders and constitutional responsibility is significant. Despite its repeated violations, the government argues that there is redaction because most of the material has been produced to the defense in advance of trial. This disingenuous claim, however, ignores the repeat nature of the violations, the lack of legitimate justification, the failure to seek court intervention, the gamesmanship and lack of candor in its responses, and importantly, the timing of the critical events within the prosecution of this case. First, in May of 2021, the defense specifically identified Brady material, but the material was not willingly produced. Instead, the government sought unreasonable delay and pressed for an all-encompassing protective order on the false basis that defendants were improperly sharing discovery material. It was a clear attempt to withhold materials to which the defense was legally entitled. This court rejected the government's overreach, summarily denying the government's attempt to wrongly restrict our investigation of discovery materials, rejecting the government's request to retroactively impose restrictions on documents it has already produced, and holding that the provision limiting defendants to reviewing witness material at their counsel's office is overly restrictive. Then, in 2021, the government's improper and unjustified redaction of 302s, those are the official notes of the FBI, impermissibly delayed the disclosure of court-ordered information until November 12, 2021, 4 days before the Pensacola grand jury was impaneled. Finch asked the government to postpone the grand jury presentation so the defense could bring the matter to the court's attention. The government refused. On November 16, 2021, the government presented the second superseding indictment in Pensacola and suggested to defense counsel that its decision to suppress information about Major Stanford's history of accepting bribes and other corruption was driven by its lack of confidence in our ability to control Finch. The court should reject this illegitimate argument, attempting to justify the government's unilateral decision to violate the court's orders and its constitutional Brady obligations. Let's get back to this footnote 19. Of course, it is now apparent why this deception occurred. At the same time, the government was seeking to restrict our ability to share and investigate discovery material. It had inserted a government surrogate into our camp to report on our efforts. Wilson confirmed he communicated with Finch on a daily basis when Wilson was working at Derwin's office, confirming that the FBI agent knew Derwin White was represented by counsel when Wilson was relaying information that the attorneys and their clients were having. Confirmation Mickey White was represented when Wilson was relaying information to the government. Again, the timing, footnote 20, and the scope of the government's redactions is significant. The government finally concedes that the redactions were redacted. At a minimum, the government's redactions, reflections of its misconduct, or admissions that it proceeded with reckless disregard for defendants' constitutional rights and fairness of due process. Only after the second superseding indictment was acquired through false testimony, manufactured exhibits, and misconduct did the government produce a portion of the FBI agent's testimony from the August 18, 2020 Tallahassee grand jury presentation, admitting that the FBI agent falsely testified about facts in this case. Remarkably, the government now concedes that it possessed the transcript containing Borghini's false testimony. but knowingly suppressed this information for more than 1 year. Such conduct was nothing short of an orchestrated cover-up. Footnote 21. Finch had identified this false allegation to Sheriff Ford as early as December 22nd, 2020, which the government had known as early as December 28, 2020, when it received copies of the material Finch delivered to the sheriff. Defense counsel also brought proof of the government's false allegations to the government's attention on January 18, 2021, yet the specifics of this unmistakable Brady material were intentionally withheld for nearly a year. Footnote 22. The government's disclosure of Borghini's false testimony was followed by defendant's motion to dismiss the second superseding indictment. Shortly after the government filed its 80-page response admitting that his sworn testimony was false, the FBI agent retired. Then, after the court ordered the production of all grand jury transcripts and set the matter for evidentiary hearing, the FBI sought to prevent and restrict his testimony. The government chose to call the FBI agent as its sole and exclusive witness against the overwhelming evidence of misconduct based on the documents and the incriminating testimony of the government's own witnesses, Mickey White, Adam Albritton, the former city attorney, and the FBI agent's operative, Greg Wilson. Compared against the backdrop of overwhelming evidence of false testimony, missing reports, missing notes, and Stanford Borghini collusion, Borghini's testimony was simply not credible. As a result, the government has been forced to concede to several critical prejudicial errors, conceding errors in a timely production of discovery material, conceding to errors before the grand juries. In sum, the FBI agent's testimony should be wholesale rejected. The nature and timing surrounding the disclosure of this critical information, which supports defendants' particularized need for all reports and grand jury transcripts, is evidence that the government was rushing to insulate itself from the constitutional misconduct before prior grand juries. In other words, the government committed misconduct before the Tallahassee grand juries and then withheld any information that would have allowed defendants to discover this misconduct. The government then presented much of the same misinformation to the Pensacola grand jury. Defendants are and have been prejudiced by the government's rule violations and discovery gamesmanship. Respectfully, the court should reject the government's claims of harmless error and good faith compliance. The court should exercise its supervisory powers, dismissing the second superseding indictment with prejudice for the repeated flagrant disregard of the Constitution, the court's express orders, and its local rules. Number 5, I'll tell you what I'm going to do. I'm going to finish this, but first, I want to thank those who make it possible.
You want to look good? You want to feel good? Little John's Big and Tall is where it's at. Right across the street from Sky's Pizza Pie, 5700 North Davis Highway. You can find out more online at littlejohnsbigandtall.com. He's also a member of the iTex trading community, where your iTex dollars are welcome.
It's a hot time in Florida, and my friend Ryan could make sure your air conditioning is running at peak efficiency. He could even install a new one, built to a higher standard, American standard. Find out more at pcairrepair.com.
All right, we're on page 21 of 35. The government concedes to misconduct before the Pensacola grand jury. The admissions by the government, the sleight of hand arguments revealed that false and misleading information and legal instructions were presented to all 3 grand juries, including the Pensacola grand jury. A rush to indictment. The government's 216-page response takes issue with the defendant's characterization that the Pensacola grand jury was rushed. The government's claims, however, are belied by its own admissions on the record. In fact, the government's senior prosecutor stated to Tallahassee Grand Jury Number 2 that a fair presentation to a redaction, yet somehow the entire presentation in Pensacola took 4 hours. Likewise, the government rushed through critical, incomplete legal instructions. The prosecutor began by informing the jurors that he will be providing blank, but will blank. Also, the government's suggestion that the jurors genuinely reviewed 63 grand jury exhibits, deliberated, and voted within 120 seconds is preposterous. Redaction. Admitting that the Pensacola grand jury deliberated for a similarly short period of time, the government's admissions of rushing through redaction of information within a matter of 4 hours placed, quote, significant pressure upon the grand jury to rubber stamp the indictment out of deference to the prior grand juries, end quote. Citing case law, find that the grand jury rubber stamped a superseding indictment after deliberating for only 10 minutes in another case. B, incomplete and misleading legal instructions. The government agrees that legal instruction to a grand jury should be accurate and not misleading. The government ignores, however, that its 2-sentence instruction on conspiracy is anything but accurate. The government suggests in its papers that the grand jury had apparently considered a single conspiracy case previously, but no reliable record evidence supports this assertion. Let's look at that. And that's footnote 23. Though the government stated on the record that the Tallahassee grand jury had considered various aspects of this case had apparently redaction, there is no clear reason articulated in the record as to why the government presented the second superseding indictment to a new grand jury in Pensacola, as opposed to the one in Tallahassee. There is simply no reason to do anything but read the pattern. So the issue here is that the senior prosecutor, according to the defendants, did not read the instructions to the grand jury properly. That's what this is about. There is simply no reason to do anything but read the pattern jury instruction. Anything less invites error. Rather than taking the time to retrieve the pattern jury instruction for a single criminal conspiracy, the prosecutor assumed the jurors were well versed in conspiracy cases, though no record evidence supports the government's argument. Likewise, the government fails to address the fact that the prosecutor's instructions on honest services also serve to mislead and confuse the jurors, describing the concept of honest services as tricky and counterintuitive. C, improper testimony regarding the attorney's fees. It is striking how vigorously the government argues that it is appropriate to mention the attorney's fees issues 3 different times, with no context and no corresponding limiting instruction. The government argues that the grand jury testimony regarding attorney's fees was proper, despite the court's previous admonishment that any suggestion before a petite jury would result in a mistrial. With no basis, pending motion, or authority, the government argues and applies a relevancy standard in a futile attempt to justify its misconduct. The government also argues that its evidence and conclusions regarding the circumstances surrounding legal fees are redacted. Yet this court has already pointed out that the government's tendency is to spin facts in the worst possible light. Wow. Suggesting that the court cannot understand how the government is taking the worst possible spin on the facts that could be made. The government's pattern and practice of flagrantly disregarding the court's rulings, orders, and instructions has prejudiced the defendants and substantially influenced the grand jury's decision to indict. Accordingly, dismissal with prejudice is warranted. D, improper testimony regarding Mayor Anderson's political platform. The government argues that Mayor Anderson's political platform of reducing bloated government spending and expenses through overhauling various government positions was properly submitted to the grand jury. Specifically, the government stated, redaction, the problem with this argument is that neither the government nor FBI agent Borghini submitted any testimony to the grand jury that Michael White fired anyone, the former city manager. The government also does not cite to any record evidence to support its claims. Instead, the government is nothing more than an attempt to support an improper indictment based on political and managerial decisions. This criminalization of political opinion and the political process is undoubtedly unconstitutional and central to the U.S. Supreme Court's careful scrutiny of honest services fraud as applied by misguided prosecutors. E, false testimony regarding the motorhome. The government's response fails to address the prosecutor's unsworn testimony before the grand jury that the redaction. Its response, the government ignores this misconduct because it cannot be refuted that the 2018 bill of sale does not contain Margot Anderson's signature or name. The government attempts to address defendant's position that FBI agent Borghini affirmed the prosecutor's unsworn and false testimony that grand jury exhibit 41 was signed by both Forehand and Anderson. The government knows this testimony was false, but suggests that the defendant's position makes no sense because of a scrivener's error in a record citation. Footnote 24. Counsel for Finch erred by citing DX41 rather than DX10, which is grand jury exhibit 41. The government omits the fact that the citation in footnote 22 included the description grand jury exhibit 41, thus Finch's position. Simply said, the government solicited false information about the title registration documents, knowing that Margot Anderson's name and signature were never included. Footnote 25. The FBI agent blames his mistake on the fact that the February 28, 2017 minutes were attached on the March 14, 2017 agenda. The FBI agent's excuse lacks credibility. The minutes for any commission meeting are reviewed and accepted at the subsequent meeting. Commission meeting minutes approved. Okay, so the timing's off on that one. F, false testimony regarding grand jury exhibit 59. The government concedes that FBI agent provided false information via grand jury exhibit 59. The government describes this false testimony as a blank and a blank. The record, however, suggests otherwise. With the government's knowledge, Borghini presented the false exhibit to multiple separate grand juries. First, the false exhibit was presented to the Tallahassee grand jury on March 16 of last year, then to the Pensacola grand jury November 16 of last year. The government and the FBI agent had every opportunity to review the exhibits for accuracy before the Pensacola presentation, but failed to do so. Borghini's redaction, however, was not limited to the grand jury's exhibit. During his November 16, 2020 interview of Commissioner Antonius Barnes, Borghini suggested to Barnes that the proximity between March 14, 2017 vote and the March 15, 2017 check was a problem for Barnes. In other words, Borghini appears in a video interview conducted on November 16, 2020. On March 16, 2021, the same blank was used by the government to secure the superseding indictment against defendants Barnes and Finch. Finally, the blank was presented to the Pensacola grand jury. The record evidence militates against a finding that the blank was blank. Indeed, the government has not shown and cannot show that the Pensacola grand jury was free of influence by this false and misleading testimony. G, the government concedes it asked improper questions. The government concedes that on more than one occasion. It posed a question before the grand jury, that redaction. This admission alone, frankly, should compel the government to agree with our request for dismissal. The government instead suggests that there was no harm in the improper question because blank. Nothing could be further from the truth, however. In this case, the prosecutor has pushed false and misleading facts regarding Finch with a complete disregard for truth. In fact, during a meeting on January 12, 2021, between the undersigned and the government, the lead prosecutor recognized that Finch has been a successful businessman interacting with countless public and government officials for the last 40 years. The government indicated that James, quote, must have been involved in criminal conduct, end quote, as a result of being in the construction business for so long. When pressed for evidence of the government's belief, however, the government stated it had no specific facts to support the statement. Footnote 26, the government has never denied this clear impropriety. Number 6, the record supports a conclusion that the government was intentionally invading the defense camp in violation of the Sixth Amendment. Now we're talking attorney-client privilege. The Sixth Amendment is violated when the government intentionally plants an informer in the defense camp. Faced with uncontested evidence and the serious doubts as to the FBI's credibility, the government now concedes its intrusion of the defense camp, but summarily concludes that the intrusion was unintentional. The record suggests otherwise. After arresting Wilson on charges of workers' compensation fraud, the investigating Bay County Sheriff's officers asked Wilson if he would speak with the FBI about the ongoing investigation. In return for information and cooperation, the FBI agreed to help get Wilson released on bond after his first arrest. Assistant U.S. Attorney Coons, FBI agent Borghini, and Wilson met in Tallahassee in July 2021 and executed a proffer immunity agreement. On July 17, 2021, the government provided defendants with a 2-page no-contact list. Footnote 27. The government concedes that Borghini provided false testimony during the evidentiary hearing. To discredit Greg Wilson's testimony, the government claims that Wilson testified falsely about his last contact with Borghini. This is huge. So the prosecution is trying to discredit Greg Wilson, an informant, now that they claim he's not an informant. Okay. But it appears the documents show otherwise. So the FBI wants to discredit him. And the government claims that Wilson testified falsely about his last contact with Borghini. However, the government grossly mischaracterizes Wilson's testimony. Wilson never testified that his last contact with Borghini was in August 2021. In fact, Wilson never provided a date of his last contact with Borghini. He merely confirmed it was sometime after July 31st, 2021. And 2, contact occurred in August 2021 after Wilson met with attorneys representing Derwin White's estate, indicating that Wilson's last contact with Borghini was after July 31st, confirming Wilson desired to end contact with Borghini as early as August 2021. Footnote 28. To date, the government still has not provided the defense with a signed written immunity agreement with Wilson, testifying that he met with the lead prosecutor and now retired FBI agent Borghini in Tallahassee and signed a written immunity agreement. Wow. The government purposely left Wilson's name off the list that Finch should not contact. Because Wilson was off the books, Borghini segregated as an informant. Borghini segregated the Wilson notes from the FBI's official case file to ensure his work with Wilson would not be subject to discovery and would be excluded from the FBI's national database in violation of the Bureau's training and policy protocols, admitting the Wilson notes from everything else and setting it aside. The government's intentional intrusion is also evident in its questioning of former Phoenix construction employee Tiffany Brandenburg before a separate Tallahassee grand jury on June 1st, 2021. The transcript reveals the government's improper inquiry into privileged communications between Finch and Anderson. Footnote 29. When questioned about his training and FBI policy, Borghini stated, quote, "I can make decisions on my own." Footnote 30. Borghini's explanation for segregating and characterizing Wilson's notes as a sensitive investigative matter is illogical and unpersuasive. The FBI agent claims that the notes were segregated and kept aside because they related to the corruption of the state attorney's office, not the matter involving Anderson and Finch. Yet the notes clearly contain discussions about the instant case, this case, containing repeat references to Finch, Anderson, and other matters related to the Lynn Haven investigation. The more logical explanation is that it was the government's design to prevent the discovery of this illegal conduct. Under normal circumstances, this line of questioning arguably might be benign, but the timing is critical to understanding the improper nature of the government's intrusion. I am going to read to you the final 5 pages after this message.
Americans for Prosperity is the largest grassroots organization advancing policies that help people improve their lives. AFP Florida seeks to end corporate welfare, expand energy options, and reform education and healthcare by giving people more choices. Sign up today and volunteer at americansforprosperity.org.
On April 14, 2021, the court granted defendants joint motion to modify conditions of release against the government's objections. The April 14, 2021 order permitted Anderson and Finch to have direct contact with or without the presence of counsel to assist in the preparation of pretrial motions, to prepare for trial, and to present common defenses. Knowing that defendants were mounting a joint defense, Anderson and Finch, the government intentionally invaded the defense camp by employing the grand jury process. The court reversed the district's court refusal to quash a subpoena, so citing former case precedent that the law is settled in this circuit and elsewhere that it is improper to utilize a grand jury for the sole or dominating purpose of preparing an already pending indictment for trial. The court observed that the timing of the subpoena cast significant light on its purposes. At the same time, the government was improperly using the grand jury to question Brandenburg about Anderson and Finch, both represented parties. Borghini was also the FBI agent using Wilson to acquire defense information. The totality of the evidence supports the conclusion that the government's intrusion was intentional. And where the intrusion is intentional, no prejudice need be shown. Regardless, it's enough that 1, the government intentionally used Wilson, and 2, Wilson relayed information to Borghini. Once the investigatory arm of government has obtained information, that information may reasonably be assumed to have been passed on to other governmental organs responsible for prosecution. All right, let's look at this footnote 32, highly redacted. Wilson was the blank that the government was using to justify the delaying of production of Brady material and for redacting portions of witness statements. The government's lack of candor is extraordinary. 33. Against the weight of evidence, the government claims blank, but at the bottom of page 2 of his July 2020 notes, the FBI agent states blank. Several of the other notes are cryptic, but clearly make mention of Finch's legal tactics and mindset. Finally, we also know that the FBI agent has a history of leaving important information out of his reports, conceding that Borghini omitted significant information from Forehand's 302 reports. Those are the FBI formal notes. Page 33 out of 35. Rounding that corner to the finish line. The government also fails to address the fact that defendants do not have to, quote, prove that the prosecution actually used the information obtained, end quote. The mere, quote, possession by the prosecution of otherwise confidential knowledge about the defense's strategy or position is sufficient in itself to establish detriment to the criminal defendant, end quote. As a result, lesser relief, as this court might traditionally order, including the suppression of evidence, disqualification of government counsel and the case agent, instructions to the jury, and or dismissal without prejudice will not suffice. The most severe sanction, dismissal with prejudice, is warranted because the government's intrusions were intentional, says the defense. 7, the second superseding indictment is again fatally duplicitous. The government's post-hearing response brief provides no new or persuasive arguments regarding the fatally duplicitous indictment. Accordingly, Defendant Finch incorporates by reference his positions within the motion to dismiss and rely in support of his motion to dismiss. Conclusion. And last page. Dismissal of the second superseding indictment with prejudice is warranted because the government flagrantly and repeatedly violated the court's orders and constitutional responsibilities. The evidence further creates a grave doubt that the grand jury's decision to indict was free from substantial influence in the government's misconduct. After a 4-hour slanted presentation filled with false and misleading information, the Pensacola grand jury spent 120 seconds reviewing documents, deliberating, and voting to return a true bill. Dismissal of the second superseding indictment is warranted, signed by the defense attorney, Guy Lewis. That was submitted to the court yesterday. Whew. Imagine if this goes to trial. If this goes to trial, the people who will be pulled up on that stand and questioned and cross-examined. So, here's where we stand in the Lynn Haven corruption case. Those who have pled guilty have yet to be sentenced. The 2 who have refused to plead guilty and have decided to take this to trial, well, now it's up to the judge. The final documents, the final pleadings to the defendant's motion to dismiss after the evidentiary hearing, concluded in, was it April? about 2 months ago. Everything's in. Now it's up to Chief Judge Mark Walker. He's reviewing it now. He could issue his ruling by the end of the week. He could issue his ruling next month. I think it'll probably take a week or two. Maybe a little bit more. And then we'll see. He can say denied, we're going to trial. He can say dismissed, but without prejudice, meaning the prosecution can go for a fourth indictment, take another bite of the apple. Or he can dismiss it with prejudice, at which point it's over. Unless the prosecutors decide to appeal. They can appeal. I don't think they will. I don't think the prosecution wants any part of this at this point. I really don't. So we'll wait and see. I would be fascinated to attend the trial. But from what I have seen, and I've only seen a little bit, there's a lot that I haven't seen because the government files their stuff under seal. And they don't stand in front of the judge and give their arguments. I couldn't see it. So from what I see, I'm betting that the judge will dismiss with prejudice. Then we'll have to see what the prosecution decides to do. I have the feeling they would rather just blame the judge and say, look, the judge let political corruption continue. But I'm telling you, if you look at the evidence, does the evidence support the charges? Not that I've seen. Not that I've seen. And I'm telling you right now, you know that I wanted local politicians arrested by the FBI and prosecuted. But if Mike Thomas or Hector Solis were facing these charges with this evidence, I would be arguing that I don't see the evidence. Now, there are a lot of other politicians locally and officials where the evidence is a hell of a lot easier to prove. But I'm telling you, if James Finch and Margot Anderson are guilty, if they are, and it is shown, we can go visit them in jail, send them letters in prison. If it's not, then this is wrong. And that remains to be seen. But I would hold that same position on politicians and officials I have reported on for years. We've got to have a fair judicial system, a fair investigative prosecutorial system. And maybe it'll shake out that way in the end. But I'm telling you what I've seen so far. And I'll continue to share with you as I get it and as soon as I get it, before anybody else does. All right, I'm going to wrap it up. Thank you for being with me. If you appreciate my work, here's how you can support it. And I need it. You can become a patron at patreon.com/Bernie Thompson. It's like giving a tip every month, as little as $5. And you can quit at any time. It's easy. And best of all, it's anonymous. Nobody knows you're doing it. You can do that at patreon.com/Bernie Thompson. And of course, I want to thank the Unknown Patriot, as always, for supporting the show. And I want to thank you. If you sat through all this, it was a lot. I'm grateful my voice held up. I think it's just about time for another pickle break. If somehow, that got the saliva flowing. All right, I'll see you next time.